Commissioner, next I have Mr. Halderson, Chandler Halderson.
We'll call the state of Wisconsin versus Chandler Halderson. That's 21 CF 1568 appearances.
Andrea Raymond for the state of Wisconsin.
Mr. Halderson appears personally in custody with attorney Catherine Dorrell. Good afternoon.
Afternoon. And Mr. Halderson, if you could just give us a thumbs up so we know that you can hear everything okay. All right, he's given a thumbs up. So we are scheduled for an initial appearance. Attorney Dorrell, have you received a copy of the criminal complaint that was recently filed?
Yes, and we waive its reading.
And as far as an address, what should we use for Mr. Halderson for purposes of mail?
Likely the Dane County Jail, but the address on the complaint was his address before his arrest.
Okay. Well, maybe we'll get to bail and then you can let us know which of those you want us to use for purposes of mail. And is he eligible for public defender or does he need to contact your office?
He is eligible.
All right. Then, so it looks like there is a bail hearing earlier in the week, $10,000 cash bail and pretrial services was ordered. I will make a finding of probable cause for the charges in the criminal complaint, and we'll address bail. I should note that there was a public safety assessment that was done previously. That was for the bail hearing, just on the charge of false info on kidnapping, that recommended a signature bond. If anybody doesn't have a copy of that, we can make sure that you get that before you proceed with the bail arguments. All right, with that, Attorney Raymond, your position on bail.
Your Honor, first off, I hope I don't know if you've had a chance to read the criminal complaint. I realize it's quite lengthy and it was filed right around the 1:30 time. I was hoping to kind of limit my comments for the privacy of the family and others involved, but I'm happy to speak more at length if Your Honor wishes. The state is asking though for $1 million cash bond. Should the defendant post, we'd ask for GPS monitoring, a ban from any weapons, ban from living in any household where any sort of firearms are kept, a ban from the Oak Springs Circle in both DeForest and Windsor. It's kind of an odd street where one side of the street is DeForest and the other side is Windsor. Additionally, that if he does post, that he stay at whatever residence he is staying at for 24 hours a day and be on house arrest. Obviously, these are very serious and very violent charges. And more charges are expected as the investigation develops. We know in this case, and it is outlined, or at least some of the instances, not all, but some are outlined in the criminal complaint, where the defendant has taken steps to both destroy and conceal evidence, including human remains that were dismembered. Because of the vast steps that this defendant has undertaken to hide his crimes and the broad spectrum of lies that the police have uncovered, there's substantial concerns about his willingness to come to court. And thus $1 million cash bond really is the minimum amount of cash necessary to ensure his appearance. I certainly can give Your Honor more details if necessary.
Sure, and I had an opportunity to skim it pretty quickly. I was able to hone in on enough of the facts that I believe there to be probable cause. I also reviewed the probable cause affidavit for the homicide charge and the other related charges that were added on. I had not read the probable cause affidavit for the false information, but based upon my quick review of the criminal complaint, I think there's probable cause for that charge as well. So if you want to supplement anything, if you think it's important, as I did skim it pretty quickly because it came in as we started court here.
Just that There is a lot of evidence in this case. We have specific evidence of the defendant taking steps to destroy or conceal video and other factors. There is a web of lies that is quite impressive if it wasn't, frankly, so tragic. But in any case, we do believe $1 million is necessary. And after Ms. Dorrell speaks, if Your Honor has any questions, I'm happy to answer them.
Sure. Attorney Dorrell, your position?
Well, thank you, Your Honor. We were in court on July 12th in this case, for a series of charges, rather. And I made a bail argument then. The state requested $1 million cash bail, and a $10,000 cash bail was set by Commissioner Frengen. At that time, my client had been in custody and remains in custody since his arrest on July 8th. And now here we are, July 15th, and we're seeing actual criminal charges for the first time. When we were in court on the 12th, he had been booked into the jail mainly or only on in relation to what is now charged as count 2. But it was clear that it was contemplated that the other charges would be happening. They simply weren't written into the jail system. As soon as the $10,000 cash was ordered, it became almost a farce, because immediately some authorities went to the jail and then added the rest of these charges that you see here today onto what was holding him in the jail. And I guess under the theory that that just buys them more time, where he can't post bail, doesn't have access to bail, even though we appeared and bail was set in relation to the events we see here. So he's had no meaningful opportunity whatsoever to post bail since his arrest on the 8th of July, because the minute we got a bail that was reasonable, the state immediately put another hold on him for the charges they were already investigating. I would note that almost the entirety of this criminal complaint talks about investigation and activities that would have predated that July 12th initial appearance date. And so I have to pose the question, why did it take so long? Why was he held in jail this long without any meaningful access to bail? But pivoting away from maybe what some might consider, technical legal arguments that may or may not have merit, depending on your point of view, I would reiterate what I said on the 12th, which is Mr. Chandler Halderson, sits here today with no prior record, a lifelong resident of this state, a high school graduate, involved in many activities, such as Boy Scouts, church groups, school activities, the things that show he's been a problem-free part of this state and this community. Moreover, Mr. Halderson would agree to conditions such as electronic monitoring, the search as suggested by the state, whatever the court would deem appropriate in this matter. Now, the state does allege in the complaint and here today at this hearing that there is some false statements made. What is missing, though, is, of course, prior missed court dates, because he has no record, but also any attempts or efforts or plans to flee the jurisdiction. And that should be a consideration at bail, for bail as well. So we continue to make the same request we made on the 12th, $10,000. That is a reasonable amount, given my client's indigency. If he could come up with that amount, for him, that would be like coming up with $1 million, honestly. And there's other things that can assure his return to court. Thank you.
Thank you. And Attorney Raymond, you can respond.
Yes, Your Honor. There is in the criminal complaint, unlike what Ms. Doral said, there's a lot of references to things that happened on the 13th and the 14th after the IA on Monday. Additionally, Monday's hearing was only on the charge of false reports of missing persons. It was not on homicide. It was not on mutilating a corpse. It was not on hiding a corpse. And this is a ongoing case. Ms. Doral brings up Boy Scouts, and she harped on him being an Eagle Scout at length on Monday. Well, in this case, you're going to learn that there is evidence of rope and knots being tied, such that an Eagle Scout might do. And the fact that he has no prior record, although relevant, also is overshadowed by the fact that he has now entered the criminal justice system with a bang. These are the most serious charges that anyone can be charged with, and frankly, we expect more. Thank you.
All right, Attorney Doral, you can respond if you wish.
Yes, just one thing. In looking through the criminal complaint, and I've done that several times now, it is not until page 11 that there's a reference to any activity occurring in this investigation after July 12th. And that relates to one single paragraph partway down the page of 2 sentences that talks about something that occurred on July 13th. Again, there's 2 sentences on page 12 of something that occurred after July 12th. I would concede that if those 2 items were excluded, there would still be probable cause for the charges alleged. That's all I have. Thank you.
All right, and I wasn't at that hearing. Did the commissioner consider that he was going to be charged with a homicide and setting bail at that hearing, or is that not a part of the analysis?
No, he in fact said specifically at this time, the only probable cause is for false information on a missing person, and that was all he was going to set bond on.
If I may, the state certainly did argue that those charges would potentially be coming and making it in their recommendation for $1 million at that time.
And Ms. Thomas, briefly, just a question, would the nature of the charges change the recommendation in the public safety assessment?
Yes, they would. When the public safety assessment was completed for the group file case 21GF 37034 on July 12th, it was just on the one charge of false info on kidnapping. And today the charges would make the outcome different in that there would be a current violent offense and also a step 2 making it cash bail.
All right. And obviously, given the short amount of time between the last hearing and when that PSA was conducted and now, all the rest of the relevant information about criminal history and the like are still accurate, though.
That is correct. It's just that we only do 1 report per arrest, so that's why it was not amended for today's purposes.
Understood. All right, and I'll certainly allow counsel to respond to any of that if you wish. Otherwise, I'll make my ruling. All right, well, let me touch briefly on the order of events and the concern over another booking coming in after that bail hearing. So as I understand it, Mr. Halderson had the bail hearing consistent with the local court rule. It was held timely. on the false information on a kidnapping charge, and bail was set. And I think it looks like it got set for an in-custody hearing today for charges or to review bail again, and we do have a criminal complaint now. So I'm not sure that that had a great effect. Obviously, if Mr. Halderson had been able to post the bail, he may have been out for a period of time, and then they could have arrested him on the homicide. And Rule 206 also was not designed with these types of serious, complex cases with the volume of evidence. I understand the frustration in what Attorney Dorrell is talking about. I'm not sure it ultimately made much of a difference or delayed Mr. Halderson's ability to get into court with a criminal complaint, because it looks like the court said, well, I'll give you till Thursday to have a criminal complaint on the providing false information and maybe anything else. There are a number of factors that would suggest Mr. Halderson's a good risk on bail. Because he doesn't have a prior record, that's where we see everybody on a public safety assessment. If there's no prior record, they don't have missed court dates, they don't have prior convictions, they haven't been out on bail, and they always come out as a signature bond recommendation unless it's the violent offense plus the nature of the charge, which makes this a cash bail recommendation. So there are certainly things in Mr. Halderson's favor as far as bail. And the issue is he going to appear in court? I don't get to set cash bail to punish him. He's been convicted of nothing at this point. These are simply charges, allegations, and it'll be for the court process to play out to determine whether the state's able to convince a jury beyond a reasonable doubt that he committed these very heinous offenses. The factors in favor of significant cash bail are certainly the nature of the crime. It's gruesome, it's violent. The potential penalties are significant, mandatory minimum prison for 20 years. And I reviewed it relatively quickly, but I also reviewed the PC affidavit for when the additional charges were lodged, which went into some of the lies by Mr. Halderson and attempts to cover things up. I think he's got a lot of incentive to not appear in court now that he is finally charged with first-degree intentional homicide and the other charges. And as far as circumstantial cases go, it appears to be it appears that there's some fairly strong evidence given the observations of Mr. Halderson in and around the home where the body was located, the lies that were told to law enforcement and others, the observations of his body, the statements in regards to all sorts of blood on him, but no injuries that would be consistent with somebody having all sorts of blood. So there's also, I think, a strong case, even though we don't have a direct eyewitness saying he committed this offense. I don't know whether he's going to be charged with additional charges, and I'm one who is always reticent to factor those in because I don't know whether that's going to happen. I don't think that's fair when assessing bail to assume that somebody's going to get charged with some other stuff. And that's, I guess, why it makes sense that the commissioner at the earlier hearing didn't take that into account, because you just don't know. And you don't even know if there's probable cause really unless somebody reduces it to writing an affidavit. But things have changed greatly since that bail hearing. I am going to set $1 million cash bail. There's just too many years at stake in prison for Mr. Halderson. I am going to also order pretrial services if released, so he needs to contact them immediately upon his release. If they don't answer the phone when that happens, you need to be providing them your phone number, your name and case number, and respond to that when contacted. Although given the nature of the case, maybe there'll be some stuff behind the scenes if bail were to be posted So pretrial services has a heads up on that. I will order you equipped with a GPS to monitor the house arrest 24 hours to be in your home unless it's for purposes of going to and from court. I will order a band from Oak Springs Circle located in DeForest and Windsor. I will order that you not use or possess any dangerous weapons, as that term is defined by the state statutes, which obviously includes firearms and other items that are specifically designed to be used as weapons. And I will advise you that that would also include any other items that are not necessarily designed as a weapon, but if in the manner you're using them or you intend to use them are likely to cause great bodily harm or death, then you would transform those into a dangerous weapon and be prohibited from using that. It may be surplusage given that, but given he's not to reside anywhere else other than his home, I don't know whether we need the condition about the residences and other firearms. I also don't know if there was an objection to that part from Attorney Doral, but it seems a bit surplusage. Attorney Raymond? Nope, you're on.
Sorry,
mute.
that's fine, Your Honor.
All right. I want to make sure on the record that the bailiffs have provided Mr. Halderson the pretrial services information, so he has that, and they're giving the thumbs up that that's been done. And I assume, but I don't know, so I'll ask Attorney Doral, do you want a timely preliminary hearing? Oh, you're on mute as well.
Yes, please.
All right. And should we use the jail or the other address for purposes of mail for the time being?
Jail.
Okay. And July 28th at 2:30 will be the preliminary hearing date and time. And if there's nothing else from council, we'll be adjourned. Thank you.